Judge, I'm also present on number 13, the Mako and Krakenberg matter. That was just on for a final GAL review. We've received that report. I'm imagining we can just strike today.
Ms. Petrie, any objection to that?
Well, the only issue, Your Honor, is that there are my client does have some issues with the report. I know the parties have been trying to work through some of the conflict. But we are going to need some orders at some point, so I'm not sure where the court would direct us to go from here, except to file a motion to adopt or change, or I'm not sure what
that
the
would be
court would want me to do.
Well, that would be the process. I mean, this is on just a review to make sure we had the order in place. So.
And have we gotten the final, or are there going to be any more revisions?
It was my understanding we received the final already.
That is the final report. There was an intermediate report filed, and then there's the final report.
Okay.
So, Judge, at this point, I would just ask that we strike, and then if Ms. Petrie and I are unable to reach a resolution, we'll just follow the appropriate course and file motions.
Very good.
I am. Apologies. They moved my buttons.
There you are. Okay. I just wanted to make sure. I think we were just on to make sure everybody was in compliance with meeting with you.
Yes, I have met with both parents as well as the children, done a home visit at mom's, and unable to do one at dad's because he is out of across the state.
Okay. At this point, you've got everything you need, correct?
Well, there is, I don't know, maybe Ms. Holder wants to address.
Yes, I know where Ms. Twilight, where Ms. Corey is going with this, Your Honor. Currently, the reason we have a GAL is because there has been no parenting plan, and the court wanted to bring in a GAL as well as Mr. Fowler, because he disagreed with some of the provisions. So currently, we just have a temporary family law order in place. My client has decided to move to Arizona. Her family is there. She already has secured a job, but because there is no parenting plan in place, we would like the court's direction about what to do as far as filing a notice of intent to move, because there's no parenting plan in place. We are unsure that we need to file that notice of intent, but we would like the court to be aware of what is going on, as well as Mr. Fowler, because normally it would be notice of intent to move and then the objection from the opposing party if they'd like to object. We're not exactly sure what to do in this situation since no parenting plan has been finalized. Does the court have any guidance as to how it would like us to proceed?
Yeah, I think you would need to file that notice.
Okay.
I think that applies even if there hasn't, I mean, if we've got a case pending. I'd have to look at the statute again, but I think that still applies.
I spoke with Ms. Corey this morning, Your Honor, and my understanding, based on her training manual they have for the GALs, is if there is no parenting plan in place, if a move arises during the course of litigation, that it would revert back to RCW 2609187 subsection 3 in determining how that should be addressed as far as what is good for the sibling, if siblings being together, if the move would be good for the children. But I am still fine filing a notice of intent to move if it would make things easier, and it would make things easier if Mr. Fowler would also like to file that objection.
I think that would be the cleaner approach. I haven't done the research on that specifically, but that would just be my assumption based on my understanding of the law. But
Your Honor,
yes.
What actually started my conversation with Ms. Holder was I was unsure whether to go ahead and include that particular piece in my report, the criteria for a move, or whether to, because it usually comes up after there's a parenting plan in place, and I realized we didn't have one yet, so I was unsure about whether to include that or not.
Well, if we do the notification and if there's no objection, you wouldn't need to include it. If there's an objection, then it would apply, I would think.
Okay.
So I think that kind of fleshes out the issues.
Okay. And if the court might, Mr. Fowler, what is your most recent address so that we can send that notice of intent to move to you directly?
That would be P.O. Box.
Okay. Anything else on that matter today?
I have nothing more.
Okay, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Welcome. So the Ramos and Ramos Curial matters, I do have, looks like agreed orders, I believe. Mr. Baldwin, have you seen these?
Ms. Baldwin told me that orders have been going back and forth. I think there may have been a recent, I don't know how recent change, so I don't know if Your Honor has in front of you. The parties intended that there would be orders entered today. So I'm assuming yes, Your Honor.
Well, I know they've been signed up by Ms. Winkles. I don't.
I'm here for Ms. Baldwin because she had indicated that the parties had reached an agreement on the temporary orders and sending the matter over to the 21st. I think extending the restraint, but I'll defer to Ms. Winkles here initially.
Yes, I did get an email about an hour ago from Ms. Baldwin that asked for the Word version, so I'm not sure which one she wanted to change. It
Okay.
appears though that one she did want to make a change on. I'm assuming it's not the Shirley matter, because I would assume that that would not be the one that she wants to change. The other one did have some caveats in there that she might have wanted to include on that. So I would assume that the Shirley one's okay. However, we can shoot Your Honor an email and let you know of that and get it to you before the end of the day.
And that'd be my request. If Your Honor could hold off signing anything right now, and Ms. Baldwin, if they're going back and forth, should have them sign to Ms. Winkles, and everything should be fine. I think over to the 21st, is that right?
That's correct. And just so Your Honor's aware, for the record, the GAL is attending today, and that might be my fault for not getting her information soon enough.
Okay, just a second here. That would be Ms. Gail.
I'm not concerned about being here. I'm here anyway today.
Okay, all right. So this will be over the 21st. Now that much I knew. I don't know about the details, but so we're over to the 21st at 1 o'clock.
Thank you,
All
Judge.
right. Thank you, Your Honor.
Thank you.
I assume, I don't know if there was a default issue or requested, there was a response filed, so I don't know this is going forward. Ms. Green?
Yes, Your Honor. I only have it on the docket because I'm asking for attorney's fees. We received this response on Friday, so we have already put in a bunch of time for my client to file the motion and to get pleadings to the court in advance of this hearing, only to receive a response just 2 business days ago. So we are concerned that my client has expended more than $1,800 in attorney's fees and $237 in costs. I did present a new order to the court this morning that changed the previous default to granted to a denied order. But in Section 10, I'm still requesting attorney's fees of $1,000, which is only half of what my client has spent.
Brief response, Your Honor.
Sure.
My client works nights and he works about 12 hours a day on some days. I was unable to get a hold of him, and then unfortunately I was out due to health reasons for about 3 weeks. And then unfortunately had a family issue as well with a surgery. It is our fault. Absolutely. We did communicate that we were trying to get those documents done. I never disappeared. He does have counsel. It was that was essentially the issue. My client works nights and my health issues. I never hid those things from any party here, and I made them aware that I was trying to get those documents and that I'd have them as soon as I could, and we did file them as soon as we could get them. So I'd ask for no fees. I think in this case, I'm not sure why a motion for default would cost so much money. I'm not sure why it would cost anything more than a couple $100, but I'll defer to Your Honor on that.
Well, obviously, Your Honor, our office is out of town. We have to pay a courier to deliver documents to be timely and filed. It is a substantially more expensive cost for our client than having it local. But the other issue is that we've been waiting 3 months since Smith Winkles appeared on the case. It wasn't even the month that we filed the motion for a default and gave her notice that we waited. We waited more than 3 months before we proceeded. 2 months before we filed the motion, and then our hearing was set a month after that. So I don't know what period of time is necessary to get a response with everything going on, but I just have to preserve the argument for my client. She had to expend money, which only required a response from her client, and that was it.
And just so you're aware, Your Honor, the parties live together still, and this was filed a long time before I got in. It was my understanding that the parties were getting back together, which is why nothing was filed for over almost a year in this matter. He had no attorney up until recently, and I literally just came on to do a response. But they could have defaulted him at any time in the last year, and they didn't, because it was my understanding that they were getting back together. They do live together now. They continue to reside together. This is just a placeholder, this response. I would imagine this divorce isn't going to go through, but in any event, I was hired just to do that.
And just to correct, the petition was filed September 17th, 2023 and served on respondent. It has not been over a year, so I just want to clarify.
And I'll defer to her. I'm not looking at the file this time.
All right. Well, I'm not going to order fees on a motion for default. So I'll deny the most those. I'll deny the default, but I'll strike the fee language.
Okay, and you did receive the order that was emailed to Superior Court this morning then?
I did.
Okay, that's the only section that needs changed, and I believe Ms. Winkles, you had a copy too.
Yes, I have a copy.
And you're fine.
Right.
I'm just going to indicate approve via Zoom with that change.
Absolutely, Your Honor.
All right. All right. Sign that order.
Thank you,
All right.
Your Honor.
I
Thank
just
you,
assumed this needed to go to an assignment docket for hearing.
I would concur with that until I received an email. Of course, I insinuated that to counsel yesterday, confirming that understanding, and received an email back today that no, she wanted to push forward on apparently a trial on the affidavits on today's docket, which I don't think is proper. I don't think it complies with the statute. You don't have a motion in front of you. So I don't think we can do any of that. So I would concur that that gets set to a regular trial assignment docket at which we can find an hour on the pleadings, hopefully soon.
And Your Honor, I disagree. The RCW 2609.175 specifically states that the court has to approve oral testimony for a hearing on a child support modification. There's a form to do so, and Mr. Zandy did not provide any form or request any oral arguments for the sake of this case. And so under the statute, the court can resolve it based on the pleadings alone. So there's no need to set it for a trial under the local court rules. It's assigned to a trial docket if it's going to exceed the time needed on the docket or 30 minutes. Since there's no oral arguments, the court should just make a decision. I don't believe it needs to be reassigned.
Well, looking at that same statute, it states at any time after responsive pleadings are filed, any party may schedule the matter for hearing. So it wasn't even a motion. It was just a docket notice was filed along with the initial petition. There's no declaration. There's no motion citing what the relief is. There's been obviously no discovery that's been exchanged. And I think the statute is quite clear that a responding party's answer and worksheets shall be served and answer filed within 20 days after service. I don't want testimony. Oral argument, I think, is appropriate. But again, that can be done so on the affidavits as we traditionally do in this county. My understanding of certainly the general practice is you put that on a trial assignment docket, you find an hour for oral argument between the parties between the lawyers based on the affidavits that have been submitted, which include a declaration, and the court makes a ruling at that time. I'm not asking for testimony of the parties, and I think that would incorrectly is what counsel is citing in that. And this is a modification. It's not an adjustment. There's a difference between the two.
And the court has all the information. I don't know what arguments or further information is needed. All financial documents have been provided, tax returns, pay stubs. Everything is in the pleadings already. I don't know why additional information is required and why it needs to be cited on for a hearing when it's clear in the statute that the court can make a decision based on the pleadings.
For one, we just got the first declaration, which cites reply declaration of Amy Rieger, petitioner's response to petition to modify child support order. So again, we get a late submission for a motion that has never been filed, and here we are kind of shooting in the dark. And that's what the statute tries to avoid. That's obviously what the local rule tries to avoid as well. So I agree with counsel. This should be fairly simple, but unfortunately, nobody's willing to give credit to my client for a overnight residential credit, despite it being joint. Nobody's willing to give him credit for the insurance that's paying for the kids. She's asking that the tax exemptions be addressed. So therefore, I think you have to put this to a formal hearing. You can't just be allowed to dictate what you think the parties are saying.
Well, the first problem is I assumed it was going to be put on for assignment, so I hadn't read all the materials, and there's a lot of them in this one. And that normally these are done on declarations, which is what statute requires on a hearing that we set specifically for these, because there's typically a lot of documentation to review through. When I looked at this one briefly, it looked like there were a number of changes being requested in the support order. So, and this isn't just like indicated, it's not just an adjustment based on passage of time or something. So I can put it on, I don't know what tomorrow looks like for assignment, or I can put it on for next week.
Tomorrow is open.
Okay, so I could put it on for assignment for hearing on the 15th at 1 o'clock,
No, it's 9 a.m.
9 a.m. Okay, I know we've made a lot of changes, so.
Fees?
That would be fine, Your
I
Honor.
try to
'cause I
avoid
do-
this hearing and give, again, input to that effect, and here we are. So I'll use council's words from the last hearing. That's coming at an expense to my client. This is the case that was just before you several weeks ago on the petition to modify the parenting plan, which didn't have a factual legal basis either that you denied. So here we are once again with something improperly cited by council.
And I don't believe that's accurate. I followed the statute, Your Honor, that says specifically I filed not only the family law docket notice, I filed the notice of hearing, which is the statutory form that the Washington State has approved for this basis to have a hearing based on the ruling from affidavits and pleadings filed. That is what I've asked for. I have not broken any procedures. The only reason that the hearing is set on assignment, like you said, is if it's to exceed the 30 minutes, which I did not expect it to do, because there's no request for oral argument or oral testimony. So I don't know what arguments would exceed that time frame.
Well, first off, the statute sets, you set a hearing after responsive pleadings are filed, or I assume after there are none filed after the answer prayed in a summons. This was noted on when it was filed. That's certainly not timely. But I'm going to defer. I'll reserve on fees for the.
Very well. Will you make that bench order, or do you want me just to put something together real quick?
If you want to shoot something over,
Okay,
I will set it on, and I'll just reserve on that.
thank you.
So the 15th at 9 a.m. for assignment, Your Honor.
That is the 15th at 9 a.m. and that is a Zoom hearing.
Thank you, Your Honor.
All right, Mr. Baldwin, Ms. Petrie, the Smith and Gutierrez matter.
Yes, Your Honor.
Yes, Your Honor.
So this has been put over a couple of times, so I'm not sure where we're at on it today.
We can proceed, Your Honor. I think the only question I had, my staff noticed that the clerks had flagged the disqualification. And looking at it, it was back in 2019, prior to the entry of the final orders. I wasn't sure if that would have had an effect on Your Honor's ability to have prepared or reviewed the pleadings prior to today. Otherwise, I think Ms. Petrie's indicated she'd like to proceed, and we can do that today.
I must have overlooked that. I didn't look at this recently. I looked at it quite a while ago, but I thought this had already been addressed by Judge Scudder, but I hadn't seen that disqualification. I probably shouldn't hear this.
I think the disqualification was prior to the final orders in the original parenting plan in 2019. So I don't know if it has effect, but if Your Honor's not inclined to hear, we could put it to another docket. I just wasn't sure if that had an impact. So that's the only reason I brought it up.
Let me check real quick. Looks like that was filed by Ms. Stivey.
And I have no issue with Your Honor hearing it. I just wanted to make sure that that was cleared before we proceeded.
Thank you. If both parties are fine with me hearing it, I think I can hear. This was signed by Ms. Stivey, not by Mr. Smith specifically. And I think I got to get into that. So if you want me to hear it today, I can hear it. I did review it enough to do that. I missed the disqualification. My apologies.
Yeah, I have no problem with Your Honor hearing it, and I would like to proceed.
Okay, that's fine.
We filed a motion, Your Honor, on behalf of Mr. Smith to dismiss functionally the action objecting to the relocation. I think it can be relatively brief. My client filed a notice of relocation and served it personally by a non-party on June 19th, 2022. Respondent filed with the court an objection to relocation July 13th, 22, using mandatory forms 721 and 720, the objection to relocation and the summons including the notices required of the moving parent to defend the action. Proof of service was filed by mother respondent July 13th, but was disputed by declarations of the petitioner and witnesses. As a result, the party, our client by counsel, objected to service on August 3rd, 2022. Commissioner Nelson instructed the respondent to reserve or serve the pleadings. On the 24th of August, 2022, they appeared in court. The matter was struck because service hadn't been made. December 20, 2022, Judge Hahn struck a motion for temporary orders by the respondent mother due to lack of service, and at that point entered a stay on a GAL order until reconsideration was heard. December 28th, as cited by counsel for the mother, Judge Scudder denied reconsideration, lifted the stay of the GAL appointment. He did include language in dicta referring to the statute as stating only they had to serve the objection and not specifically referencing a summons. Our position is that the summons is an essential part of the service requirement. 2609-480 identifies service of the objection. It must be in the form of either a modification or other proceedings adequate to provide grounds for relief. 2609-006 requires use of mandatory forms that includes the summons and the objection in this particular matter. 2609-010 identifies civil practices to govern actions in domestic matters. 428 talks about the commencement of an action, and 428-020 personal service is made specifically by serving the summons as part of the action. 428-080 sub 16 service made in the mode provided is personal service. Summons shall be served by delivering a copy thereof to the defendant personally or in abode service. Our position here is under the statute, the objection to be properly served is not just referring to handing it to a person or having someone hand it to the person, but includes all the necessary legal pleadings to effectuate service, which under 428-020 is the summons. The summons is an essential part of all civil actions to initiate the proceeding. It provides essential mandatory language for defenses and obligations on the party receiving the summons and whatever goes with it, whether it's a petition or an ejectment, a dissolution, a modification. The summons is an essential element of effectuating civil procedure and civil process as required under the RCWs for domestic cases. The court, after lifting the stay, did receive a GAL recommendation that recommends the move and one video or phone visit a month with the client. The current parenting plan where the court to dismiss allows for visitation as agreed by the parties. And there's a lot of reasons for that given the history of the case. Your Honor, we're able to see in the history what got us to this point, and the limited parenting plan include contempts against the mother for taking the child and not returning him to the father. That was in 2021. There have been significant issues with the mother throughout the course of this case and a refusal to comply in the time required. Service has to be made within 30 days of receipt of the relocation. Service isn't proper without the summons. The summons was not served properly. The action should be dismissed. The mother still has remedies. She can move to modify the parenting plan under a modification with a request for adequate cause. But absent that, this action should not proceed in the current form. And that's our position, Your Honor.
So just a question before I'll hear from Ms. Petrie, but the question, this is on for, I mean, the case is pending on the basis of, maybe I'm misunderstanding the status of the case. I know there was
Well, this is the problem, Your Honor. There was a final parenting plan put in place. My client has not had, since he moved, my client has not had contact with the child, period. None, zero. The parenting plan said that it was father's discretion, but even the court has said that she needs to at least have a monthly phone contact or video phone call. And the court reiterated that again at the second to the last hearing, stating that we have to get those phone calls in place. We've reached out to Mr. Baldwin. I spoke to him. We confirmed we've gotten nothing back from him with any kind of an offer or let me see what my client's willing to do. Nothing, no communication. So it's been 2 years that this is pending. And now he brings this motion to dismiss based on a summons that is not required under the statute. The statute specifically says, and this is RCW 2609-480, a party objecting to the intended relocation of the child or the relocating parent's proposed revised residential schedule shall do so by filing the objection with the court and serving the objection on the relocating party by means of personal service or mailing in any form, blah, blah, blah. There's nothing in there that says that a summons is required.
Counsel, let me stop you for just a minute. I'm trying to understand the posture of the case before you get into your argument. This is a motion for default, correct? That's what it's done for.
Basically, yes, Your Honor, because there was not appropriate service. There's a motion for dismissal is the, I think, the proper form. I apologize if there was a misstatement, but it is functionally a dismissal request akin to a summary judgment type because there was a fatal error in the initial pleadings.
But the motion is filed as a motion for default for failure to file an answer. I'm looking at court document 139.
Yes, Your Honor. I think there was an error in the form that was not, I think, how the parties proceeded on its basis. The response was that the case should not be dismissed because of that failure. It was intended to be more of a summary judgment dismissal. If the court would like, I can refile that, but that's what the parties I think were proceeding based on. I apologize for an error there.
Well, I guess I misunderstood the motion because this is the reason why I was questioning what we were doing, because Judge Scudder ruled on the motion for default previously. And so when I read the motion for default, I was trying to understand what we were doing, because I thought that would already been ruled on.
And Judge Scudder denied the motion for reconsideration on the appointment of the guardian ad litem. It's a specific question in front of him.
Actually, it was a motion for revision. And Judge Scudder confirmed that a summons was not required. And this was done on December 28th of 2022. And it was a denial of the motion for revision, not reconsideration.
I apologize. Judge Hahn on December 20th struck the motion of the mother because of a finding there was a lack of service. December 28th, Judge Scudder denied the revision. I wrote reconsideration in my notes. That was an error. To revise the order of the guardian ad litem. That was the issue in front of Judge Scudder. He did state that he denied the revision because service of the summons was not required. Judge Hahn had previously ruled and found that there was a lack of service without the summons and struck the motion that the mother had put on December 20th. There was inconsistency in an open issue, and we are in a point where we are asking the court to dismiss. If the court would like additional legal analysis, I'm happy to submit that. That is what we're asking the court to do.
And we would ask that that be denied, Your Honor. There is no long distance parenting plan in place. That needs to be done.
That's a separate issue. That's not the issue. The issue I'm looking at is this was filed as a motion for default, which is what I prepared for. And when I went back through, I looked back at the hearing the ruling by Judge Scudder on December 28th of 22, which indicated essentially the service already dealt with this issue of the response. So what my thought is today, what I'm inclined to do is not move forward on the motion for default. If you want to file a motion to dismiss, I think that's a separate issue.
Very well, Judge.
I'm happy to consider that. I just think under the motion for default, which is really what I had prepped under, and my apologies for that. I guess maybe I didn't read your motion as clearly as, but I guess I was proceeding as what was captioned as.
I understand, Your Honor. It's safer to assume that I misspoke somewhere in there. So I will happy to clarify. You're denying the motion at this time, and I can make a renewed motion to dismiss.
And Your Honor, I am requesting fees for today and for this motion, given the fact that it was already previously ruled upon by Judge Scudder and then brought again. And this is also, this is a constant battle. This is an objection to relocation action that has been pending for 2 years. My client has been an active participant in this action from the very get-go. It's been a constant battle, constant delays, and lack of communication by the other side. And in the meantime, there's been no contact between the mother and the child for 2 years. So I am actually requesting a minimum of $1,000 in fees today, Your Honor.
If I may respond briefly, Your Honor, there's no request for fees in the pleading or in the motion. Your Honor's
It was
indicated
in our
you're free to
responsive declaration.
You were free to renew the motion. And at this point, there's been no motion for temporary orders made by the mother. Ms. Petrie and I spoke. I was waiting for her to give me a proposal. She was waiting for me to give her a proposal. Neither side has made a proposal at this point. So, I mean, I don't think fees are appropriate. At the very worst, the court, I'd ask her to reserve on fees.
Your Honor, motion for default when the issue has already been ruled on is frivolous. It's a basis for fees. And just another delay tactic for this case. And it was in our memorandum of law that we requested our fees. And that was submitted on April 5th, 2024.
Well, I'm looking, this is the one it was signed by Haley Jaskiller.
Yes.
Well, that doesn't request any fees.
I believe it did at the very end.
I'm looking at the very end. It says you're asking for a denial of the motion for default.
That's what's reflected in the memo I received as well, Your Honor.
Sorry, I didn't see it in my prep this morning. I just don't remember where I saw it.
I'll reserve. I'm not going to order anything today.
Thank you, Judge.
So I'll deny the motion. I don't have an order, so if somebody wants to send one, I'll be happy to sign that.
Very well, Your Honor.
Thank you, Your Honor.
Way over on my other screen over there. Maybe over here and see. There we go. Okay, so. It looked like there were 4 objections.
There are, and I think what we kind of need here is we've been acting under operating on older parenting plans. In this case, it's been continually fluid throughout time. So I guess we need some clarification. If you see the first couple of objections, these are related to provisions that I think essentially the ship has sailed. They're no longer issues. The first one under 4B, council included the language that was in previous parenting plans about further psychological evaluation. This is the case where we gave you significant amount of information that shows what my client has done since that order was entered. Had further information from the GAL in her updated report that shows he's accomplished quite a few things related to that. My position that provision is no longer necessary. So we're just asking that that be stricken. And you'll see that in future objections under 14, it's a lot of the same. So I don't know if you want to take these all at once, consolidate my arguments, or if you want to take these one item at a time.
Either way, I guess, Ms. McLean, do you have a position on just generally on these? Because
yes, generally, we were working off of the second amended parenting plan, excuse me, that was entered on December 15th of 2023. And you indicated that you were making minimal changes to that order. And that included the holidays, if we were able to work those out, and to provide for Mr. Moses's visitation weekends to be defined as Thursday to Monday. That's all of the changes that you made. Council indicate there was absolutely no finding as to whether or not Mr. Moses has complied with the requirements under paragraph 4. Council suggests that the court didn't order Mr. Moses to participate in the joint counseling with Ms. Rosen. But if you look at the second amended temporary parenting plan that was entered in December, page 2, paragraph 4B1, the second paragraph is exactly the same. That says Jason Moses must participate in co-parent counseling with Catherine Moses, facilitated by Charlotte Rosen, to commence as soon as possible. That's still an ongoing order. That's still an ongoing service that these parties are supposed to be participating in. And if you remove that, one, that was not argued at the time of the hearing. So you didn't rule on that. Council's attempting to get a second bite at the apple for things that he didn't argue at the time. Then if you do away with those provisions, then he wouldn't have that obligation. And again, the court has already ordered that he participate in those services. And we outlined during our argument that the concerns about whether or not Ms. Lovely's evaluation complied with what the court ordered. So you limited what you were doing as far as making changes. And in fact, if you go down to 14H, council's argument.
Let me stay one at a time, because
okay,
that's simpler. So
the court didn't rule on that. The court made no changes to those provisions in 4B.
Well, I think it was implied. I'm certainly not trying to take any bites of any apples. I think it was just implied at the time of the hearing. I think it was, I thought, somewhat stipulated or at least acknowledged the fact that my client has undergone further testing. If you leave that in the order at this point, it implies that he has more to do. And frankly, my position at the time of the hearing, I think it was readily discussed ad nauseum, was the fact that he's literally done everything that's been asked of him and then so much more. So to include further psychological testing, because that was under an existing order, which is now a ways old and it's extremely stale, doesn't seem appropriate. When this case does eventually go to trial, it's going to confuse the trial court as to, okay, what did the court contend back in May of 2024 about what further services did he need? So it puts you kind of in an awkward position with that. As far as the co-parenting counseling, again, they've been doing this. They've been doing this for an extended period of time. If you want that to remain in the order, I have no objections with that. My concern is just that a lot of these provisions, this is where we just need some clarity. A lot of these provisions don't apply. They're extremely stale.
Okay.
But that psychological evaluation in that one is significant.
Well, first off, we didn't argue the specific provision. I didn't make any changes other than the specific ones I did about the visitation adjustments. I also didn't, and I wouldn't want this to be interpreted to say that by readopting this, I'm imposing a new requirement that for anything that has been fulfilled, if that makes sense.
Right. Yeah, that's understood.
So, and I guess I don't read it that way. These are unfortunately the same kind of things we see in a lot of dependency orders. They just continue on.
And I appreciate that from your honest perspective. I just don't know that you're going to be hearing this trial. If somebody else hears this trial, I don't want them to put an offer file.
Well, I think clerk's notes could indicate that
okay.
I didn't make any changes in these other provisions.
Fair enough.
So, I mean, to the extent they've been complied with, that doesn't change. To the extent they're still ongoing, they're still ongoing.
Okay. Yeah, that's clear in the record. I'm fine with that.
Okay. So, and I think that applies to probably all but the one as to how you calculate the days.
Correct. And my suggestion, and again, this is certainly one that I don't think is worth significant discussion or argument, but the weekends start on Thursdays. So typically, I think it makes more sense to define the weekends by Thursdays, given that's the first day of the overnight. Council's requested that remain at Friday. And again, I'll leave that to the court's discretion, but for simplicity purposes, I think setting those weekends with a Thursday as opposed to a Friday is going to be much clearer and effective for these parties moving forward.
Ms. McLean?
So the prior provision was defined by Fridays. These folks, or at least my client, has already been scheduling out on a calendar for the boys so they know when their visitations are based upon that Friday. You indicated that at the time of the hearing that the only thing you were changing was that the visits would be from Thursday to Monday instead of Friday to Sunday. And so it's our position that it should remain being defined as Friday because that's what they've been exercising for the last 2 years.
The last 2 years have been Friday to Sunday. This is now Thursday to Monday. So
I meant that the definition has been by Friday for the last 2 years.
Right. The only thing that would, I mean, and I didn't go through a calendar to see what effect this change might have, and it might have 1 or 2 days out of the course of a year. I'm inclined to leave it. I very well may have ordered Thursday as the calculation period if that would have been raised, but I didn't.
Again, I'm fine with that. I think it's worth following swords over. All right, appreciate that. Thank you, Your Honor.
So with that, are you okay with this order then?
Yeah, I think that makes the clarification that we needed.
Okay.
Thank you.
Yeah, I'm going to hand this down to you. Put an initial on here just a second. Well, since you're here. All right, sign that order with the understanding that's in the clerk's records. Teeters and Brown matter.
So I filed my objections, Your Honor, on April 29th, and because of the extensive nature of those, I did provide also a proposed order.
And Your Honor, I incorporated some of Ms. McLean's changes, but not all of them. There was just a few that I think were pretty important that I wanted to be able to address.
So just so council's aware, the order that I received another order from you yesterday. And that's the same order that was filed as a proposed order that we received back on April 17th, it looks like.
I don't know why that would be. Your Honor, did you receive a comprehensive order that incorporated some of Ms. McLean's changes in it? I'm just trying to see if the messenger may have delivered something they had previously.
I didn't. The one that was emailed to me that has your signature on it is the same order that was previously filed.
Yeah, I'm just trying to see what was delivered to the court for some reason.
I have two different orders. They both appear to be, I don't know when one came in, but one of them came in, looks like yesterday.
Yeah.
They appear to be slightly different. I don't know which one is which. There's not a, just looking in the court file as to see what, so I've got two different ones. One of them, if you look at the bottom line of the first page, one of the orders includes Chris Day's name. The other does not. So I'm not sure which one of those I'm supposed to be looking at.
It would be the one that includes Ms. Day's name.
Okay.
And I don't have that order. I have not received that.
I don't either, Your Honor. The one I received in the email today looked almost identical to the previous one. I have reviewed the order prepared by Ms. McLean, which I think, if you review that one, I think that largely covers the bulk of the argument and your ruling.
I think we could go off Ms. McLean's then, Your Honor. If I can just indicate some of the bigger concerns I had, maybe the court can make some adjustments if they feel that that is appropriate, if that makes sense.
I'm fine. I was just trying to figure out which one we're working off of. I work off either any one of these. I just know which one we're all looking at. Sure.
And so, Your Honor, may I just, I think my biggest concerns on these orders are that, first of all, when Ms. McLean's client filed her motion, she specifically asked for that Ms. Anderson not be included as the separate and distinct, that Ms. Delaney be as a separate and distinct counselor. And then it somehow got changed here to just during reunification, and there was all this other language put in there. And so that was a little bit of a concern. I'll just go through a few, and I think the court can just make its decision on this. the other issue I had is I feel really uncomfortable that it somehow just keeps being put in that we're just going to continue to follow any new recommendations of the guardian ad litem, and then the language that says as well as any future recommendations of Ms. Rosen keeps being removed. When we came here originally on my client's motion to follow the recommendations of Ms. Rosen and the reunification team. And so I think it's really important to have that in there, because what I can see happening then is Ms. Rosen is going to make a recommendation like she did to expand the visits. And then those were disagreed by Ms. Teeters, and she then didn't want to follow them, which then we had to prompt this motion to follow them. Then we had to give Ms. Day to update a report, and here we are, then it's months and months later. And so I just want to make sure that there's any language that says that it includes any future recommendations of Ms. Rosen, which, if the court recalls, I did bring that concern up at our hearing. And that's the same situation on the order when it just says that we will add 2 hours of supervised visitation for a total of 3 hours every week. That it should also say, and any future expansion, recommended by Ms. Rosen, because that concern then becomes, we're going to say, oh, well, it was only the 2 hours and not anything future.
Can I interrupt? Because the order that I provided provides for that at paragraph 6A. It specifically says that they're to participate in the reunification process changes. I'm sorry.
If I'd like to just start at the top of the order and go through it, because we're jumping around and you've got me lost at this point. So if I look at the order, I'm looking at the one that was submitted by Ms. McLean. This was filed with the court on April 29th. The cover sheet that was filed should have said April 25th, it looks like. So that's the one I'm looking at.
So counsel's first argument was that she complained that my order didn't identify that we were asking for Celia Delaney to be identified as the reunification counselor for the child, or the primary counselor for the child during the reunification process. That language is specifically in paragraph 3B, where it says it identifies that her counter motion was to suspend visits, appoint Celia Delaney as the child's primary counselor during the reunification, because the current order defines Ms. Anderson as the child's primary counselor during reunification. So I'm using the consistent language from the prior order that is in my order. Her second argument was the suggestion that I didn't include language in my order about future changes recommended by the reunification team and promulgated by Ms. Day as the guardian ad litem. That's in paragraph 6A. It specifically says that they are to participate in the reunification process changes as recommended by the guardian ad litem based on the reunification team's recommendation. And that's specifically what the court ordered.
But the problem I have is that it has to come directly then from the guardian ad litem, when what is happening is, this is what happened last time. We had the letter specifically from the reunification team as to what they recommended. And then there was no agreement on it, and we had to then wait for the guardian ad litem to do an updated report, when we shouldn't have to be going through those steps. The reunification team, Charlotte Rosen, was already appointed. We should be following her recommendations. If she makes a recommendation, it needs to just be followed. There's no language including that anything that so it almost seems like it has to then go through the guardian ad litem in order to have these parties follow it. And so I just wanted specific language that if Charlotte Rosen makes a recommendation to expand or do whatever, then they're going to follow it. We don't have to go then through the guardian ad litem as well.
I would anticipate Ms. Day is simply going to shoot us an email, as she's done in the past, as far as what those recommendations, if she has any changes to those recommendations. And specifically in the clerk's notes from our hearing, at 249, you ordered, follow Ms. Day's recommendations, including Ms. Rosen's recommendations.
And so, for example, here we are in section C, in 6C, it's cleverly crafted language that just says to expand the reunification to add 2 hours. And there's nothing on there that says, or any future expansion. So it's almost like I mentioned previously, we're gonna go round and round again, because right now he only gets this expanded time. So then if Charlotte Rosen then says, well, let's expand it 1 more hour, there's going to be an argument here. Well, it's only to expand it 2 hours. And so it's just cleverly left out language. And I do think that given such contention on this case, as you can see by this file, it does need to include that if there's something in there that says, or any additional expansion of time.
paragraph 6A says that. And the court specifically adopted the current recommendation of the 2 hours additional time each week.
And the
So,
court said
and the
additional
clerk's
expansion.
The clerk's notes can certainly reference the fact that we've acknowledged that any changes that are recommended in the future are going to be implemented as recommended by Ms. Day.
Then why not just add to C that including any additional expanded time? There's a reason why this is being limited on Ms. Teeter's behalf. There's a reason why, and I brought this up in the argument with the court, and I brought it up when we were here previously at the other presentment, because I foresee this problem coming up, that we are already now months and months past the recommendation, and very well likely could be recommending additional time, and then we're going to have to come back again for yet another hearing.
So since counsel is having this issue, I would ask the court then at paragraph 6A on the second line, after the word changes, add and or expansions or reductions. I mean, it's changes. Changes could be expansions or reductions depending upon what the reunification team is recommending and that Ms. Day supports on behalf of the child.
All right, so let me start back where I first started my discussion, because starting on page 1, and go through paragraph by paragraph, and let me tell me what your issues, if any, are. So paragraph, so does page 1 appear to be okay? Paragraphs 1, 2, and 3, A, B.
That's fine, Your Honor.
Okay. Paragraph 4, section A.
For section A, I would like it to say that, and any future changes to the reunification process as recommended by Charlotte Rosen or the guardian ad litem. Because it makes it seem like it's just that we're only supposed to follow the current recommendations of Charlotte Rosen, but not the future ones. And then what happened was there was a prior recommendation of Charlotte Rosen. It wasn't being followed, and then it took us months to get into court to schedule something to try to even have that simple recommendation followed. So my fear is that if Charlotte Rosen sends out a letter and says, I'm recommending an additional hour of visits, it's not going to be followed until we go through the process of the guardian ad litem doing an additional report or whatever it is. It shouldn't be this difficult. So I would like Charlotte Rosen to be included in there as recommended by Charlotte Rosen or the guardian ad litem.
So this sort of dovetails into the order. The order itself, again at 6A, orders that if there are disagreements with any future reunification recommendations, then neither party is precluded from filing motions. But pending further court order, the recommendations as approved by Ms. Day are to be followed or shall be followed.
But that's completely separate. That's completely separate from including recommendations of Charlotte Rosen. It's not even put in the order that we are to follow recommendations of Charlotte or Rosen other than the current ones of only 2 hours of expansion. So I don't see why we are not including her in there. That was my client's motion that was granted.
So reunification team recommendations include Ms. Rosen and her team. So if you want to put at 6.
So counsel, I have a proposal. Why don't you send me a Word form of this? I'll cut about half of this out and I'll send you an order that I actually said. I reviewed the tape on this and I didn't say most of this. I'm happy to do that. The only questions I would have, I didn't talk about Dr. Poppleton. I don't know anything about that paragraph, but that's something you all agreed to?
We agreed to. I don't know who the Stephen Mayharg is in B, but we did agree to Poppleton, Your Honor.
The court originally ordered Stephen Mayharg or such other counselors as the parties could agree, and the parties have agreed on Dr. Poppleton, but that finding was Mayharg.
Okay, and that's fine. I didn't address that. So if that paragraph is what you've agreed to, that's fine.
Okay.
And yeah, so if you want to send me a copy of this in Word, I'll adjust it to. And I reviewed the FDR. The FDR was not particularly helpful. It didn't pick up a lot of the arguments, but I'll do an order and ship it out to counsel.
Okay, thank you, Your Honor.
So you can forward that to me, Mr. McLean. I will copy everybody out on this.
Thank you.
Tiffany Jensen, present for Heather Fontes, Your Honor.
Thank you.
Good afternoon, Your Honor. William Ball for Mitch Stemmerman, petitioner.
And Ann Height, guardian ad litem, Your Honor.
Thank you. Let's get everybody on the same screen so I can see you all in just a second here. There we go. Okay, so this is on a motion to adopt the GAL report. And I did review through the parties' declarations, responses. So, Mr. Ball, I think this is your motion.
Oh, thank you, Your Honor. Yes, we were here on April 9th to review the GAL report, and I requested at that time we adopt the increase in parenting time recommendation. And so I filed this motion to do just that. It only increases father's parenting time from 6 hours to 12 hours a week. And then for one weekend, he gets one overnight, which is a pretty modest increase. It's one overnight a month. However, during the process of filing this, there's been some other serious allegations raised that I think that the court needs to make it a best interest determination on. There was some allegations. There's been two CPS reports. Two CPS investigations started in mother's household since this court's been involved, and the most recent one I think has to do with child's allegations by the half brother, at least some inappropriate touching, and I guess that's been brought up to the GAL. We're not really confident in the response that we're getting. That it seems to be just kind of brushed under the rug. Mother did say, with regard to father's request, that she would agree to the increase in parenting time once we receive the DB evaluation for father, and that has been done. So we got the DB report last week, and that was submitted with the court. It makes a recommendation that he has to go through 9 months of some counseling, and so he's going to, that's under the court order, he's going to do that, but he did complete the evaluation. He doesn't agree with all of the findings in the evaluation, and I don't know if the court had a chance to review that part of it or not, but
I reviewed everything that was filed.
Okay, thank you, Your Honor. So we think that there are some very concerning allegations that I think that the court needs to take seriously here, and they kind of are in line with what father's been saying about mother's household, and he has some concerns, and he has some concerns about her behavior and some of her parenting things that are happening there, and the outbreaks or the outbursts and the tantrums by the child seem to be in line with what he's been reporting throughout this case. So we'd ask, at the very minimum, we're supposed to come back on June 4th for the completion of the GAL report. So these recommend, just the modest increase in parenting time would only be in place for another month. We're anticipating that he's going to have, some of the positive things out of the GAL report is that, father does have a bonded relationship with the child, and that she's attached to him, and that they've had, positive interactions, which, and so we anticipate that, there's going to be a more balanced parenting time going forward, and we're concerned about kind of the strong resistance we're having to just father having, I think just pretty standard parenting time to begin with. So would ask for attorney fees as well. I think it's been pretty clear what the GAL recommendations were. They even said that they would agree to the recommendations if the DB evaluation was completed. It has been completed. So we're just been kind of delaying everything as long as possible. So we're asking that at the very least, again, that the modest increase be approved, and the court really take a look at a best interest analysis and a best interest analysis in to make sure Hadley's protected. Thank you, Your Honor.
Thank you. Ms. Jensen?
Thank you, Your Honor. Well, first of all, Mr. Ball has put in a reply declaration allegations against my client that my client has not had any kind of opportunity to respond to, and they were inappropriately included in the reply declaration. His declaration should be addressing things in my client's responsive declaration and not new items. So if the court is going to be considering any of those allegations, I would ask the court for a set over. That being said, my client also has shown in her materials that the initial CPS allegation that Mr. Ball mentioned was deemed unfounded by CPS. It is also my understanding that the new allegations that Mr. Ball's client is throwing at my client have also been deemed unfounded and unreliable. I believe Ms. Height has potentially talked with the CPS worker about that, and perhaps she can enlighten the court more on that position, should the court be willing or thinking about considering that in its ruling today. Furthermore, Your Honor, Mr. Stemmerman.
Let me stop you one second. You referenced a reply declaration?
Yes, Your Honor. Mr. Stemmerman filed a reply declaration on May 1st, in which he included allegations that
okay, I do have that one. Okay, I'm sorry.
That's okay. Okay. So additionally, Your Honor, my client, as she has stated, does not or is encouraging of Mr. Stemmerman having additional time with Hadley, provided though, however, Your Honor, that he has completed a domestic violence evaluation, which we just received, and I will talk about that in a minute, and complied with the treatment outlined therein. We have a protection order in this case based on domestic violence committed by Mr. Stemmerman against my client. And the children were included on that protection order by the court to protect them from incidents that were happening in the household. The court has reviewed the domestic violence evaluation that was just received and filed with the court. It recommends a 9-month intervention program. It also recommends a substance abuse evaluation for Mr. Stemmerman due to his alcohol use and the impacts of that likely were factors in the domestic violence that occurred in the household. And he's not started complying with any of those things as far as we know. And even more concerning, the domestic violence evaluation has very high risk for truthfulness. In other words, Mr. Stemmerman's credibility and his responses and his participation in the evaluation are subject to scrutiny and could be deemed as untruthful. So we need to take all of that into consideration when we're looking at what's best for Hadley and making sure that she's protected. Him at least beginning treatment and complying with those recommendations, I would suggest to the court, needs to happen before any increase in parenting time occurs. In addition to that, Your Honor, the guardian ad litem's report suggested that the parties each participate in Love and Logic, either a class or reviewing the book. Mr. Stemmerman has had that GAL report, yet he doesn't mention at all that he's complied with that recommendation. My client has. My client has done that and she filed her certificate. It is important that the parties be on the same page about how they're going to discipline and deal with Hadley. And Love and Logic is the way that's been recommended by the GAL, and my client has complied and Mr. Stemmerman has not. So before any additional parenting time occurs, I would request that this court have Mr. Stemmerman begin the treatments that have been recommended, both by this court in the very first hearing that we had, and also now by the DV evaluation, and by the GAL, frankly, because she suggested that Mr. Stemmerman comply with the recommendations of the domestic violence evaluation. As it relates to attorney's fees, Your Honor, I don't think it's reasonable at all to award attorney's fees. Mr. Ball attempted to get this heard before the court without a motion. We were here on a review hearing. It is appropriate for him to file a motion. He has now done so. And now we are arguing that motion because my client does not think it is appropriate at this point in time to increase Mr. Stemmerman's parenting time until some of those other prerequisites that I've already mentioned, Your Honor, are completed. And then lastly, again, I just want to mention that if the court is going to consider the new allegations Mr. Stemmerman has decided to include in his reply declaration and to which my client has not been able to respond, I would ask that the court at least reserve on making a ruling on this until my client can appropriately respond to those false allegations. Thank you, Your Honor.
Thank you. Ms. Height, do you have any comments you'd like to make at this juncture? I don't know if you received everything.
Thank you, Your Honor. I believe I have received everything. I do have a couple of things I think might be helpful for the court. I had a very helpful, and first of all, I would like Your Honor to know that both of these parties have been very cooperative with me. It's very obvious they both love this little girl and want what's best for her. That has not been an issue. They've both been responsive and forthcoming and very easy to work with. I had a conversation with Miss Lovely after I received her report, and it was very helpful because I found her report a little hard to parse out, and after talking with her, I understood why. She indicated that she felt that some of her comments regarding the truthfulness scale were directly related to Mr. Stimmerman's ability to complete the test itself. And I was going to say she struggled. She spent quite a bit of time, it sounds like, trying to figure out the best way to address that issue, because he took quite a bit longer than what she considered norm to complete the evaluations, the various sections of it. And toward the end of it, she felt that he was just mentally and physically fatigued to the point that he was leaving some sections incomplete. And so some of that relays into, it could look like trying not to answer correctly or being untruthful. So she was trying to evaluate how much of that was really going on. And so as we talked about what is in Hadley's best interest, what her basic thinking was, and I will be putting this into a final report at some point, she believes that the difficulty between these parents was originally fueled by alcohol in the home, and the fact that they are now separated and that he is no longer using alcohol, and that in itself provides safety for Hadley. She specifically, I asked her about overnight visits and what I was thinking as far as my recommendations for Your Honor today. And she clearly stated that she felt like overnight visits, she would not object to overnight visits, to increased visitation. And she felt like she is assured that Mr. Stimmerman is going to begin, it's a scheduling issue right now to begin his treatment. She was even uncertain about how much treatment, if it should be 6 months or 9 months. And she fell where she fell as far as of recommending that. She does not believe that he needs to complete treatment before he begins extended visits. I specifically asked her that. She does not feel like that was necessary. She believes that the issue of sobriety is the key issue here, and that the treatment that he will be undergoing is going to be helpful for him as a parent and as a person, and she's all in favor of him doing it, and believes that's going to be a good thing. She does not think it is essential for Hadley in having extended time. Regarding the CPS information that was brought up here, I did speak with, I apologize, I can't think of her name right now. She's in Washington County, Oregon. The CPS worker that I talked to previous to her doing her investigation, we had a pretty clear conversation about that. And I just happened to be on the phone with Miss Fontes when she was at the home finishing up her report with Ben. And I didn't speak with her at that time. She was speaking with the rest of the family, but the indication was that was going to be, what was told to me by mother was that was going to be unfounded. I haven't received any document to that effect yet, but I expect that I will receive something. The other thing I do know from speaking with Mr. Stimmerman that he did get a copy of the book that the parenting class or book that I recommended. He has gotten that. I don't know how far he's gone through it, but I know that he has at least accessed it. And then of also concern, and I think positive, is mother is beginning or is getting ready to begin some specialty counseling. It's called PCIT counseling that she's going to engage in. And part of that is, I think, going to be very helpful in helping Hadley with some of her outbursts. My concern is that I think it would be really helpful in either through that or through something else that both parents can be accessing the same information they have so far with the love and logic. But I think it's important for a child this age with this kind of outburst to hear the exact same thing, the same corrections, the same expectations from both parents. And I'm not sure what exact instrument will be helpful for that yet, but I think it's very important that they co-parent in a way that they communicate between themselves. Here's when this happens, here's how I handle it. And I think that will go a long way in helping Hadley maintain some kind of more stable way of dealing with her big emotions right now. Again, both parents love her and want the best for her. And I think we're going to get to a place where they can co-parent more cohesively and not be in conflict with one another. And I'm hopeful that that will happen. One last quick note I'd like to make for Your Honor is, if Your Honor is going to address my recommendations in my preliminary report, I would ask that you consider changing one of them. Recommendation number 3, I am requesting a domestic violence evaluation for both parties, and that has been done by one of them, and with collateral input. I would request that because there is another family law matter in play between Misty McKinney and mother, that Misty McKinney not have collateral input in that. I'm afraid it would not be a fair evaluation. So for that, I would like to have that piece removed from recommendation number 3, if that's clear to Your Honor. I was not aware that they had another, at the time I wrote that, I didn't realize that there was another issue between the two of them that is in process at this time.
That was Misty McKinney?
Yes.
Okay. All right. Mr. Ball, do you have any brief response?
No, the only thing I forgot to mention is we did ask this part of our motion that the mother completed DV evaluation, and regrettably there has been some tension between Miss McKinney and Miss Fontes, so I wouldn't have a problem with that as far as Miss McKinney not providing input to the DV evaluation. But
okay. And Ms. Jensen, did you have any response do you want to add after hearing Ms. Height?
No, I don't think so, Your Honor. I want to clarify for the court that the case that Ms. McKinney has filed is against both Ms. Fontes and Mr. Stemmerman, not just my client. So just for clarification on that. And I guess the other thing that I would request, Your Honor, is that we take this slowly. As my client mentioned in her declaration, she's interested in fostering a good relationship. I think Ms. Height has also indicated that she sees that from both parties. And that, if we're going to have a final report in June, maybe the way to start is to do a few Saturdays that are the longer duration of parenting time before we then go into overnights right away. And that, the next step in this can be overnights. It gives Mr. Stemmerman an opportunity to begin his treatment, both of which Ms. Height and the court has indicated would be beneficial to him in this process, and thereby also beneficial to Hadley. And additionally, it gives Mr. Stemmerman some additional time to read through the Love and Logic book, since we're not clear on where he is. And based on Ms. Height's comments that the parties having a similar approach to Hadley in their responses to her behaviors and her outbursts, I think, that certainly would be the best way to do that, is to just give a little more time for those things to be completed. But otherwise, Your Honor, I don't think I have anything further to add.
Okay, thank you.
Thank you.
All right, these are always challenging cases, and I think Ms. Height's done a good job of digging in at this point as to what the issues are. I I am not looking at the reply declaration with the new allegations as part of this decision. I think that there are some things that are mentioned there that I would like to have Ms. Height look into, and that really has to do with this exposure to the brother. There's some concerns about that. Everybody should be concerned about that situation. So I'm not making any rulings based on that, obviously. I haven't had a chance to reply to that. I just think that does raise some flags that are concerning. That being said, my inclination would be to adopt the report recommendations, excising out the collateral input for Mr. McKinney. And then my thought would be is we should probably, we're coming back June 4th for a review. So my thought would be as we start the weekend or the extended, not the overnights, I would say start the overnights after we come back on June 4th. That'll give us a few weeks of the longer visits. And then we can come back and we'll have a more extensive report at that point, hopefully. And we can address any other tweaks to the system that need to be done at that point. So when I was looking at, there was a proposed parenting plan. I don't know that I have a final that I could sign off on, but looking at the proposed, this was Clerk's Paper 51. Looking into this, what we'd want to do is Mr. Ball had needed a revised version of this that excises out Ms. McKinney on page 2 at about line 25. And then, see, there was.
Your Honor, I think in this proposed order, if I'm looking at the right one, under section 4, limitations on a parent, it has the overnight parenting time that the court has indicated we're going to be reserving till after the June 4th hearing.
So yeah, if we included in there that would start after June 4th.
Okay, so that would need to be added somewhere in there. I haven't had much of a chance to look through this full order, so I'm trying to do that, or this proposed parenting plan, but I'll do my best to do it as we're sitting here.
Okay. Yeah, I mean, I think it covers most of the concern. They're already doing exchanges at the Jansen Beach Target Store. I think that's existing now.
No, Your Honor, I believe they do it. I want to say at Legacy Hospital. My client would like to keep the current location in North Portland. I think that's a better location for her for traffic purposes.
Where is that located?
It's my client's on the line. May I ask her to
Sure.
unmute and comment?
Yeah, I just don't know where that's at.
Heather, can you explain where you guys do the exchanges?
We do the exchanges in the Legacy Emmanuel parking lot and in front of the offices. So it's under camera, there's security and stuff there. I looked up the distances from Mr. Zimmerman's home and it's directly in the middle. It is 50, it is directly in the middle between the two distances. It's equal.
So where is that?
Legacy, I'm sorry, some clarification on that. Where is the
Legacy?
I can look that up for you. Sorry, I don't know it off the top of my head. Portland, Oregon.
I'm going to look that up just a second. I'm trying to place where that's at in relation to everything.
And it's not necessarily just a matter of distance. It's also a matter of the traffic that's involved between downtown Portland and what's it called, the Jansen Beach area. So that gets pretty clogged up. And it's at 301 Graham Street is where the transfers are taking place right now. And I think that's northeast Portland.
It is. My thinking in recommending that is that I've had other clients use that spot. It's very easy on and off the freeway. It's just one loop and you're there, and there's a lot of cameras and a lot of activity at that spot at Jansen Beach. So my thinking was the mileage is, I think, pretty not that big of a difference, but the ease of getting on and off the freeway right there is about the best you can get along that corridor, I think. So that was my thinking in recommending that.
Honor, do you mind if I make a comment on that?
Sure.
I do know that our protection order is coming to an end here shortly in June. And for myself, before exchanges begin with Mr. Zimmerman and myself, I do feel that safest if I was at Legacy Emmanuel. Of course, you know, if the courts decide to change that to Jansen Beach, I do feel though that that's where I would feel safest to do exchanges, especially in the beginning when we are first doing these exchanges. Also, I mean, for Mr. Ball, when he was talking about driving through Portland, I do understand that challenge. The Twilliger corridor is also very congested, and as well as Portland, since I have to drive through it to get to Northeast, since I am about quite a few miles.
Okay.
Yes, Your Honor.
Okay. I guess my thought would be, I'm just looking, I mean, having dealt with that traffic down there, that you're going into the absolute worst nightmare section of Portland.
Yeah.
For both of you. I'm just wondering if maybe a thought would be just to go out by out on 26 out at the shopping mall out there.
No, that's the same. I mean, part of it is that he has only a limited time with Hadley, and it's, you know, she's sitting in the car seat behind him for that time. That's on his time. So that was the reason for some of the increase, and then also to limit the amount of time that he's actually driving. So I understand it's more of an inconvenience for Ms. Fontes. You know, it would be easier if they had less of a transition, and you know, it was an overnight parenting time. It would make sense to me if I was writing it, but.
Well, I don't think we're there yet.
We're talking about Saturdays, 7 a.m. and Saturdays at 7 p.m. or thereabouts.
Yeah, it's not
what Your Honor decides. So that is less than what it would be on a work day.
I'm looking kind of out in the Beaverton area where you come up over Cornelius Pass, because you avoid an awful lot of the traffic if you go that route on any given day, and it's about the same distance. But I'm inclined to leave it either at the hospital or move it out somewhere west out there where you actually avoid traffic, at least until we get back in June.
There's no avoiding traffic. That's still, I mean, someone is going to have to drive through traffic unless get a helicopter or something.
I think they both have to deal with traffic issues. I mean, that's part of living in Portland. So I guess it would be my position, Your Honor, at this point in time, let's just leave it where it is. And, you know, maybe some of these things will change or adjust as the schedule adjusts. We may end up getting to a place where it's a receiving parent that is doing transportation, and we can pick something that's, you know, we either go all the way or we find another place that's halfway that's agreeable to both parties. But for right now, I guess my client's position and mine would be to suggest to the court that we just leave it as is, at least for the next month.
Well, I think I'm inclined to do that at this juncture for right now, is to leave it at the Legacy. You've been going there, you know where it's at. So, and then we'll look at it again in June. And if we need to make adjustments in council, you can talk between you. Like I said, if you look out towards West Portland area, there's less traffic going that way for both parties. There's lots of businesses, there's a hospital out there. There's all kinds of possibilities that might work better, just from a traffic standpoint. Looking at the pairing plan, and counsel, I'm going to have you shoot me another one of these once you make these few changes to it. I don't think there was anything else that I noticed in there that was jumping out at me. I'll take love and logic.
So he would have his first overnight would be June 8th. So
that would be anticipated to be June 8th. Yeah.
Anticipated based off of what? Well,
we're going to have a review on the 4th, and then I would say unless there's something raised that changes my thoughts on that, that would be a good start time.
Okay.
We'll have a guardian ad litem report. She can tell me if she sees concerns with that. We'll see how the parties are doing as far as their progress in treatment, that sort of thing. It is nice to hear the parties are working somewhat against each other, but at least in to try and further the best interests of Hadley. So that is helpful to hear that. And I think that's the thing we need to keep front and center here, is that what this court's going to do is going to be not only in her best interest, but what seems to be the best benefit for her. So Mr. Ball, if you want to circulate a plan with a couple of those two changes, and I think if you have any other you have other alterations to that, Ms. Jensen, that you saw?
I think so, Your Honor, except for perhaps in section 8. It almost seems to me like the parenting time that extends to the 12 hours should not be in the section 4 on limitations on a parent, but should be in section 8, where right now it says every Saturday from 10 to 4. But, you know, maybe Mr. Ball and I can just sort of talk about where best to include those things. But otherwise, just on my overview right now, I don't see anything that looks, oh, he's put in telephone video calls, which we've never had any discussion about. So I guess I would ask that that be removed as well, since we've not communicated about that at all, or perhaps he and I can talk about whether we can reach some agreement on that. But currently that's not been ruled on by the court nor discussed either by the guardian or any communication about that related to my client either. So that's on page 6.
I see that. I hadn't seen that. If you two come to an agreement about that, that's fine. Otherwise, I'll wait on that until we get to the next report.
Okay.
Okay.
Thank you, Your Honor.
You're welcome. And that can be submitted electronically if you want.
Great.
Okay, thank you, Your Honor.
You need
Thank
another,
you.
well, if you haven't got it entered by the time we get around the 4th, that'll be a bad thing, but okay.
I think Mr. Ball and I can do it. Fingers crossed.
I would hope so. Thank you.
Thank you.
All right, thank you.
Good afternoon, Your Honor.
Hello, Your Honor. Good afternoon. All right. So, Mr. Stern, sounds like we do have a better connection today. That's good.
Yes.
All right. So, let me get back to my notes on that one. So, we had put this over mainly to get a better connection from Mr. Stearns, which we've now accommodated. I think, is Ms. Day still here? She is. There you are.
Yes, Your Honor, I'm here.
Hiding down at the bottom of my screen. Okay. So, I did have a chance to review everything again on this one. And so, counsel, if you have any brief argument you'd like to add, this is essentially a continuation of last week's hearing because we had our technical problems.
Yes, I just have a lot to add. I will note we did do a supplemental filing on April 30th, as ordered by the court. That was the supplemental text and things that we talked about last time that we hadn't had time to get on the record. If the court will recall at the last hearing, we did set a deadline for father to file any supplemental declarations or anything from him for April 29th. He did not meet that deadline and instead filed more documents late on May 2nd. So we weren't able to respond or anything to those. And I'm asking that those not be considered today because they were, specifically late. The court was very clear on everyone's deadlines. This is exactly the reason why I asked for those deadlines, because this has been a problem with every single hearing in this case. Just blatant disregard of local rules. I have sent Mr. Stearns a link to the local rules so he can access them and review them. I've explained them to him via email to the extent that I can without giving legal advice, and he simply refuses to abide by them. So that's just one thing to note. Other than that, our motion for contempt hinges on the same issues that we discussed a couple weeks ago, which would be the curbside transfers, as well as communications involving the children, disparaging remarks about mother, pressuring the children not to do school activities because it's going to take away from dad's time or it's going to hurt his feelings, talking to the kids about the case, asking them to take pictures of mother's house, referring to mother disrespectfully, which is specifically in the parenting plan. There is a clause that says neither party shall use abusive language, swear words, or similar vulgar language when communicating with the other parent. I think that's clearly in there. No party or third party shall speak with the children about the court case or put pressure on the children regarding the case. I think that's pretty clearly continuing at this point. I don't think I need to elaborate a lot more other than what we've already filed and what was contained in Ms. Day's report that was completed back in November. Mr. Stearns has been clearly on notice that this isn't a problem. Ms. Day raised it in her report. The court at the entry of temporary orders and when these temporary orders were determined, that was discussed at that point in time. And, my client at this point is concerned not only that it continues to happen, but we really question whether or not Mr. Stearns is even able to recognize or control these behaviors. This is ongoing from what was noted in the GAL report. The GAL initially recommended in her report that father undergo a psych evaluation with collateral source information. and review of the court file. The court initially declined to do that. My client is renewing her motion for that at this time. Because honestly, at this point, the children are being damaged by this. The children are being put in the middle, and the parties, there's obviously conflict between these parties. They've separated, whatever their interpersonal issues are, the kids need to be left out of this. And this has been going on for years, as noticed by Ms. Day, since the separation of the parties when the children were very young. And it's psychologically damaging them. So my client is asking that the court set a requirement for father to complete a psychological evaluation by a date certain. If that is not done, or at least scheduled by them, because I do understand, scheduling of those right now, there's not a lot of availability, but we need to see proof of at least scheduling or attempting to schedule that by a date certain. And he needs to update us, when he's going to undergo that evaluation. If it doesn't happen by whatever deadline the court wants to set, we would ask that the court review visitation to see if there need to be restrictions in place to protect the kids. My client is asking that, father be found in contempt. We're asking for attorney fees because this has been, again, ongoing. We've attempted to address this outside of court directly with Mr. Stearns. We filed this contempt back on, I believe it was March 1st. We had issues with service. We've had ongoing issues with Mr. Stearns not only continuing these behaviors since receiving the motion and being put on notice, but also the ongoing delay of, refusing to file timely court documents, even when he was served. So my client has incurred significant expense here, and not just this hearing. Like I said, prior hearings, this is an ongoing pattern throughout this case, and it's not clear that Mr. Stearns has any intention to actually follow the court rules or the court's orders. And I think that sanctions are appropriate at this time. So we're asking that he be found in contempt and that he pay for Ms. Duke's attorney fees. She had requested in her motion that he pay 100% of her fees related to this contempt action, and that she be permitted to file a fee declaration prior to entry of orders so we can give you a total of what those fees are. Alternatively, if the court wants to order a sum certain, we can discuss that as well. But I think the ongoing pattern here, justifies 100% payment of her fees, because this never should have had to be filed in the first place. He was on notice. He knows what he's supposed to be doing. He knows what he's not supposed to be doing. And there's just either a lack of ability to control these statements and behaviors, or just a disregard and a refusal to comply, or look out for what is best for the children. So that's Ms. Duke's position on this.
All right, thank you. Mr. Stearns?
Yeah, sorry, I'm gonna do my best. I don't really know where to start, but it mainly started back with the temporary parenting plan. I was not given enough time to submit paperwork to that. As I was trying to do that, I was served with child support paper. I wasn't given enough time to serve my paper for that, so they imputed my paychecks to a job that I no longer have 3 jobs ago. And in the middle of that, they served me motion for contempt, which wasn't served to me till March 28th. And all I'm trying to do is figure out how to respond properly. And Miss Dennis's miscommunication of refusing, I haven't refused anything. I've tried my best to submit forms and motions and paperwork where I can. That's all I can really say. And with the accusations of abusive use of conflict, I don't tell my boys anything that involves the case unless it changes the schedule and when they're going to be with me or not. Most of that is false from what she says and what I tell the boys. I don't cuss. I don't say derogatory things towards Mrs. Duke. I'm very direct with her, but that's about it.
If I can comment on that, that summary of the timeline here is completely false. We again he filed documents prior to the temporary orders hearings. The court, he had adequate notice. We followed the timelines. The court did impute his income because he's voluntarily unemployed, or I'm sorry, underemployed. There was argument about that. This is what the court has ruled. All of that was dealt with at the same time. This contempt motion was filed several months after the temporary orders were entered, so no one was serving him with anything during the temporary orders hearing or anything like that. Again, the temporary orders are largely based on, the recommendations of Ms. Day. And we did have a contested court hearing on that where the court entered the orders that are now in the court file. Those were not entered by default or anything else. Mr. Stearns did file responses. They were not timely, but they were considered by the court. And he appeared at the hearing and orally argued as well.
Okay, you had raised a concern. There was a declaration filed 419 that he filed. You were concerned about the one that was filed 5-2, correct?
Yes, because yes. So
okay.
Let me see. So 419, I believe, was prior to the last hearing. I believe it was the afternoon prior to the hearing. I think our last hearing was on the 20th. So the court had, let's see. Oh, no, our last hearing was on the 23rd. So we received it on the afternoon, Friday afternoon. You had not received it yet, I believe, at that point in time because of the late filing. Based on that, we set this over. I requested that you set firm deadlines so that there was no confusion about when any supplemental documents had to be filed. And that's the deadline that I'm referring to was missed with regards to his 5-2 filing.
Okay, I just want to make sure because one would be timely, the other wouldn't be.
Yes.
Okay. So I did not enter this temporary order. I did have a chance to look through it. There's a temporary child support or parenting plan order. There's a lot of language under paragraph 14 that I assume that was Judge Evans ordered that language.
That was also included. Most of it came from the guardian ad litem specific recommendations, and then Judge did adopt that. Yes.
So I looked through the text messages and things which are probably the critical pieces. The thing that I guess there was some real concerns raised about the girlfriend stepping out of the house at one of the exchanges, and that's not part of the order. So that itself is not a violation of the order. So that's certainly not, it probably is ill-advised, but it certainly was not part of the order. The pieces, I guess, that concerned me were some of the text messages about taking pictures of the household and not telling anybody, that sort of thing. Those are the kind of requests to kids that draws them into the middle of these things in ways that are not helpful to the child. Not particularly helpful to anybody, but particularly not helpful to the child. And there are a couple of texts that were probably crossed the line as far as appropriate language between the parties. So I think at least on a technical basis, this probably does rise to contempt based on the language of that order. This appears to be, this is the first, looks like the only contempt motion in order in this case, is that right?
It is, it is, although I would note that we did file it relatively soon after those temporary orders were entered. The temporary orders were entered back in, I believe, December. And this was filed, I believe, on March 1st initially, although obviously it was delayed due to some service issues and things.
Okay. So, Mr. Stearns, what you need to understand is you got the document that says temporary order and temporary parenting plan. The language in those orders is the language that you have to follow unless those orders are changed. I'm not in a position to do any changes to those orders. That is not a request before me today. This is simply a request enforcing the existing orders. It seems to me that the nature of the texts, even those, they could probably be interpreted in different ways, do cross the line as far as the specific language of those orders. Like I said, having the kids take pictures of the house, and particularly the comment about don't tell anybody, that kind of thing. Those are the kind of things that pull kids into really, really unhealthy, healthy mindsets, particularly in the middle of these things where they're stuck in the middle with very little power to do anything other than try and keep their parents happy, which is not their job. So I am going to make a finding of contempt based on those texts as well as the ones that were fairly inappropriate language. I'm not going to order full fees. I have, the parties appear to be somewhere in similar financial circumstances. What I will order today is I'm going to order $750. That's probably nowhere near what's been charged, but that's what I'm going to order as far as a contempt hearing on this one. So if you want to provide an order to that effect, I'll be happy to sign that. That could be done. Do you want a presentation time on that, or do you want to?
Yes, I can. And then we also need you to address, so as part of her motion, she was also requesting the mental health evaluation.
Ms. Day, what's availability and what's the purpose of that in this case?
So I had recommended the mental health evaluation due to some of these similar issues. What appears to be father's failure to recognize his behavior as being damaging or hurtful. The text messages, the pictures during my investigation, discovering that the children were, not allowed to call mom, that there was a lot of the using the children to go back and forth and gather information type of stuff. And in my discussions with father, he just simply fails to grasp and understand it. And that's where I came up with my concerns that a mental health evaluation might be appropriate. So that was my recommendation. That was discussed at length with Judge Fassett in the November and December hearings. And she said she wasn't going to order it at that time, but if the issues continued, then it should be considered. And I think that's where we are now. If you believe that that is necessary. I would also note for the court that the complaints about the timeliness and the length of time to file and respond has been an ongoing thing. And we've had at least 5 or 6 delays in hearings just in the last 6 months. Every hearing is delayed at least once, if not twice, due to this refusal to kind of follow the rules and respond appropriately and timely. And I realize as a pro se litigant, it's difficult sometimes to manage that, but it's not difficult to understand when you're telling your kids to do something like take pictures and don't tell anybody, or when you're telling kids that you don't want them to do an activity because it's going to cut into your time and mom's doing this to make your time less time with your dad. One of the things that Judge Fassett had indicated at that hearing was that the kids were to attend activities. They weren't to be restricted due to the parents' time, that it's about the children's time. And so I just think that that's really my concern. If the court feels like that they're ready to make that decision, I think that's an appropriate decision to do a mental health evaluation with some collateral input. I think mental health evaluation is probably appropriate as opposed to a psychological, which is extremely expensive, and I don't think that's affordable. And I think that that's not going to be helpful in getting somewhere if the father can't afford to do it and there's no progress made then. A mental health evaluation may be sufficient to identify some issues, a place for him to talk about his frustrations and maybe get some different coping skills.
Did you have somebody in mind for that, or some?
My thought was that he could use something like Columbia Wellness that's available to him in Woodland, and that they have flexible fees and are state approved. So if he has state medical, I don't know what he has for medical. That's what I would recommend as a mental health evaluation with some collateral input.
I think given the fact, I guess this has been discussed previously as well as with regard to the guardian ad litem, I'll order a mental health evaluation, and that could be done at any provider that is approved by the guardian ad litem. So I don't know, Mr. Stearns, you can contact her. She can give you, appropriate folks in different locations. Sounds like there is somebody down in Woodland that may be reasonable. So I'm going to have you do that. And I don't know what their timelines are on those things. The mental health evaluation should be fairly straightforward to get relatively quickly, as opposed to a psych eval, which is probably not what we need here. So I guess I'd like to see that accomplished within the next 30 days, unless there's a scheduling impossibility with the provider. So you'll need to get a hold of somebody shortly. They may need to see a copy of this order. So the 30 days will run from whenever we actually have an order in place. But you can contact Ms. Day. She can give you some thoughts on who might be appropriate and who she would be willing to approve. And then we can go from there. Okay.
Okay. May I just add something, which was an original problem with the GAL report, is there was a bunch of information that wasn't added, a bunch of misinformation, such as me asking my kids for information. I never asked them for information. They voluntarily give me everything. There's a bunch of other information that's not correct. That's originally what I was trying to submit paperwork for litigations for the GAL report and the temporary parenting plan, and then I was served with child support and then the motion for contempt. And that's why I haven't been able to properly give my paperwork, because I haven't had the proper time.
Do we have a final GAL report in this at this point?
Yes, Your Honor, that was filed in November.
Okay.
Yes.
That's
And Mr. Stearns has raised these, like this was also litigated at the time of temporary orders. These same allegations have already been litigated.
okay. So if that was done in November, where are we at on the final on this? Just ready for setting for trial?
Yes, it should be set for trial. We should move to the trial setting docket and get ready for moving this case to finalization at some point.
It would probably make sense. I mean, I could put it on a docket for that if you want today, or we can have you noted on.
I can note it on. I'd like to confer with my client about that and availability and things too. And I think it's also going to a little bit depend on when Mr. Stearns could get his evaluation done. So
okay. That makes sense.
I mean, and I'm happy to cite it on as soon as we get a little more information, either from Mr. Stearns or from Ms. Day. I think we can collaborate on that.
Okay. So do you want a presentation date? I'm not here in 2 weeks. I could be here next week or on the 28th if you don't have an agreed order.
I believe I can do it next week as long as everyone else can. I can get this order out within the next day or two for everyone's review.
Okay.
That's fine.
Up to you.
Okay. So I'll take a look at it on the 14th at 1 o'clock for entry of an order.
Thank you.
Thank you, Your Honor.
You're welcome. I have Tiffany Olson.
Mr. Olson.
Tiffany Steinweg.
I'm here.
There we go. All right. So I believe this is our last case. This was our ongoing trial review from some time ago. And I know there was some issues that were brought up the last time we were here. Let's see here. Just a second. It's loading slowly. So, Mr. Olson, did you get a copy of the declaration she filed?
No, I haven't, Your Honor. I didn't serve him with it.
Okay, he kind of needs to have that so we can talk
I'll
about
have the police department serve that to him.
it. Okay, can we just give him a copy out of the clerk file? Can we do that? It's in order or not? That was her declaration. Is that something we can do? Okay, how much does that cost? Okay. So it'd be about $1.50. It's 3 pages, and you can get a copy here.
Okay.
So I'm gonna have him pick up a copy at the clerk's office.
Okay.
And then I can put this on for next week. And then he can take a look at it, and I'll consider what your concerns are.
Okay.
Okay.
Okay. Has he turned in any paperwork or?
I've got some paperwork that I got from my treatment facility. Unfortunately, everything that seems to happen to me is taking forever. And since I'm doing good in treatment, they're only UAing me once a month. So I had to request that they put in once a week UAs, and they are doing that. And it's supposed to start this week, and I don't know what day. But I have a letter of compliance right here.
Okay. So what I want you to do is I want you to they'll give you a cover sheet at the clerk's office. I want you to file a copy of that and get a copy to her so she can see that you're in compliance.
Okay. Okay.
And then pick up the copies of what she's got, and then we can come back in next week and we'll talk about all this.
Okay. When next week then?
Same time.
Okay.
At 1 o'clock. He's got a treatment report. He's going to get that to you. Any problem with him having that delivered, or how do you want to do that, ma'am?
No, I guess my concern is we just keep coming back and it's the 45 days of clean UAs and we haven't seen any yet. So I'm having to miss work and all this to come back and, like.
Well, I haven't seen the treatment report he's got, so I don't know what it says. It may be documenting that. I don't know what does. I don't want to take a look at it until you've had a chance to see it. So, I mean, I can set this out farther. I
would prefer that we set it out further just so that
okay, that's fine.
Unless he's stating that he has 45 days of clean UAs, it's pointless for us to come back next week because nothing's going to change.
You don't? Okay. So do you want to come back in 3 weeks or about a month maybe?
Yeah, that would be great.
That work? Do you want the 28th of May or the 4th of June?
Let's do the 4th of June.
That work for you, sir?
Yeah, that'll work.
Okay, June 4th. Get her your documentation, and then if you get some updated documents, you need to get that to her as well as file it here. And then I'll consider all this, and he'll get a copy of this from the clerk's office, so you won't have to get that to him.
And I'll accept it via email if that's easier for him.
Okay.
Okay, that'd be good.
Okay, perfect.
June
Thank you.
June 4th at what time?
June 4th at 1 o'clock.
1 o'clock.
And it'll be towards the end of the docket. So if you're not here right at 1, you're probably just fine.
Okay, thank you.
Okay. All right. I believe that is everything on our docket. We will adjourn.